Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer. And in a recent video that I did, there were some comments from Brian and Easy Bake Barbecue. I think I've got that name right. About, hey, what do we do when we're served with discovery in a debt collection case? And so I really wanted this to be in a couple of parts. It may be actually longer than that, but this first part I want to just talk about what is this written discovery. So we talk about things like interrogatories, requests for production, requests for admissions. What is all that? And kind of what's the theory behind it? What happens if I don't respond? And then in the next video, and I think that they have both sent me some discovery that they received, and I'll just use that as sort of sample discovery and say, if this was in Alabama and I was answering this discovery, this is how I would think through it. And maybe that will be helpful. And then there may be some additional videos in this, but let's just talk about what is this stuff. So interrogatories kind of sound like the word interrogation, and that's what it is. It's a written form of interrogation. Now, they don't, bend your fingers back or stick things up under your fingernails, but it's an interrogation in writing. So they ask you questions, tell us the date that you first used the credit card or whatever it might be. And again, we'll look at sample questions. And so those are to be responded to in writing. And so this is different than a deposition. Deposition, at least 99% of the time, that's done face-to-face or, Zoom, where we are asking questions of a witness and they have to respond in real time to us. Well, this, you get it, you typically have 30 days to respond and you write out your response, okay, and any objections you have. Well, what are requests for production of documents? Well, kind of like the name suggests, you're being requested, and when they say request, I mean, you have to do it unless it goes against the rules. But they're saying, hey, we want you to produce or turn over documents. So it might be all the credit card statements that you received, all your bank records, whatever it is, they request that. And then the final piece of the puzzle for this written discovery are things called requests for admissions. And if they're done right, these will be single fact statements. And you either admit or you deny. So it might be admit that the plaintiff, Midland Funding, purchased your debt from Synchrony Bank. You have to admit or deny. Now, sometimes they'll put in multiple facts. That's not really proper. It's supposed to be one single fact per question or per request. And then you admit it. And if you admit it, hey, it's established for the whole case. They don't have to prove it because you proved it by admitting it. If you deny it and then they have to go prove it, then a lot of times you can be required to pay their attorney's fees for having to prove something that you should have admitted. Okay, so let's put all this together. So interrogatories are maybe identify the witnesses that know about the situation. List all the times you disputed with your credit card company about this particular account. Okay, so they're just trying to get some information and then they'll follow up in more detail. Request for production is, hey, I want to see all bank statements that reflect any payment made on any, on this credit card debt that we're suing you on. Okay, so in the last 5 years, 7 years, any payments you made, give me the monthly statement for the credit card, or give me the canceled check, or whatever it might be. Requests for admissions are to pin you down on things. And sometimes there's simple facts. Sometimes it's sort of the whole core of the case, like admit that Midland Funding now owns your debt. Well, if you admit that, I mean, you've just proven that they own the debt, okay? So what's the danger if you don't respond to this? Well, let's start with the last one, which is request for admissions. If you do not admit or deny, if you don't respond to those within 30 days, at least that's the rule in federal court, Alabama court, where I practice. If you're in a different state, check your state. But if you don't respond within 30 days, boom, you've admitted those. And most states say they don't have to do anything. It's just automatically they're admitted. So I see so many people get burned with this because they read all this. They go, I'm not answering this. I want to go to trial. Well, the problem is if you admit all that stuff by not responding, you may never get to trial because they may just win automatically. So if you don't respond in time to interrogatories, requests for production, they can file what's called a motion to compel. So remember, a motion is just a request to do something. To compel is to force you. So a motion to compel you, to force you to answer these questions. Now, typically before that, they'll write you a letter, they may call you, they'll try to make some attempts to get you to respond. If you don't, they file that motion to compel, and then you're put on a deadline. And if you don't respond to that, now the court can, if you're the defendant, and really this video is about when you're being sued in a debt collection case, so the judge can enter a default judgment against you. And so you lose because you didn't respond to the discovery. So some pretty bad consequences if we don't respond. So what we'll do in the next video is just go through some of these sample questions, interrogatories, requests for admissions, requests for production, and I'll just kind of give you my thoughts. Not telling you how you should respond. If you're representing yourself, you have to figure that out. But just sort of my thought process as I go through these, and I'll point out, hey, this is really dangerous, or this is an objectionable question in my view if this was in Alabama. Here's why we would object. Here's how we would object. And if I can leave you with one thought, is take this very, very seriously, because this is the reason most people lose their case when it's in my world, what's called circuit court. That's the court where we have jury trials. And if it's over $20,000, it has to be in circuit court. Now, it can actually be in there if it's a little bit less, but those are sort of the bigger cases. I see almost everybody that's sued there and they represent themselves, they lose before they ever get to trial. They lose because of this discovery. Now, if you're in what's called small claims or what's called district court in Alabama, typically there's no discovery. I mean, absolutely no discovery in small claims. Very rare in district court. So we typically we're sued, we're served, we file an answer, and then we get a trial date. But in circuit court, we're sued, we're served, we answer, we go through all this discovery, then we have motion for summary judgment, and then maybe we get to trial. So just understand, if you have a lawyer, your lawyer will take care of it. But if you don't have a lawyer, you've got to know your state's rules for interrogatories, requests for production, requests for admissions, motions to compel, because you really can lose the case without ever getting to the merits, which is a shame. Do you really owe this debt? Does Midland Portfolio, LVMV, do they really own this debt? We never get there if you fall into this trap of not handling the written discovery properly. So that's what we'll do in the next video, is go through to show you some examples. And I hope that that's helpful, and appreciate you watching. Have a good one. Bye-bye.